Hello, I'm Amanda Moore. I'm the Director of the Clearinghouse Community. Welcome to the Advocacy Exchange for October 2017. Both the Advocacy Exchange, which is our monthly conversation with advocates advancing change, both it and the Clearinghouse Community are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. My guest today is John Young. I'm happy to have him here with us. John's a senior attorney at the Legal Aid Society in Louisville, Kentucky. He's also there, he heads up the Low-Income Taxpayer Clinic at the Legal Aid Society, and he's joining us today from Louisville. Thanks for being here, John. How are you doing?
I'm doing well. Thank you for having me.
We're glad that you're here. So John wrote this month's Clearinghouse article. It's called Tax Law 101 for the Legal Aid Practitioner. And you can find it at the address on my screen here, povertylaw.org/clearinghouse. It answers some of the most common tax questions that legal aid clients have, and that's what we're going to talk about today. But before we get started, I want to let you know how you can be part of the conversation. We would love to hear your questions, hear your anecdotes if you have experience with this. Just let us hear from you. There are a couple of ways that you can do that. One is that I know most of you are watching this through YouTube Live. And if you notice, if you're on a desktop to the right of your screen, there's a chat box there. I see that lots of you have said hello. I'll get to those in just a second. That's how you can let us hear from you with questions. If you want to go ahead and try it out, let us know who you are and where you're watching. We would love to hear from you. If you're not so into live chat, that's okay. You can also email me. I'll be monitoring email while we're talking. My email address is on the screen. It's Amanda Moore, M-O-O-R-E, @povertylaw.org. So it's a couple ways that you can get in touch while we're talking. I'll also let you know that today's conversation is being recorded, and everyone who registered for today's event will get an email afterwards. There will be a link to the recording in that email, as well as a link to John's article. So be on the lookout for that. So we do have some people who've said hello. We have Karen in Milwaukee, and William in Kansas City, and Joanne in Los Angeles. Thanks for being here. I hope you'll share your questions as we go along. So John, now to the task at hand. Let's talk about tax law. I'll admit tax law is not usually the first practice area that comes to mind when I think of our clients and the legal problems of people who don't have a very high income. So how is it that legal aid lawyers usually encounter tax issues with their clients?
In my experience, most frequently, it's in the family law context. At my office, the family law cases that we handle are divorces for victims of domestic violence. So with our clients adjusting to a new familial status, being single, and divorcing, there are tax implications to that. They have to look at whether they're able to claim or file, have a new filing status, and whether they're able to claim their children for dependent exemption, for child tax credit, or the earned income tax credit. Now the probably most significantly to our clients is the earned income tax credit, because the federal government has run an anti-poverty program through the IRS with the earned income tax credit. This was done as part of the bargain for welfare reform to reward people for working. So as of 2016, a single filer claiming the earned income tax credit with 3 children could maybe get up to $6,269. And that's a refundable tax credit. What that means is even if they don't owe tax, then they may get that money.
Got it. Thanks, John, for that good intro to what we're going to talk about. We'll get into more of the specifics of some of those issues that you brought up. I want to say hello to a few more people who've let us know they're watching. We have Zuju in Las Vegas, Solomon in Hudson Valley, New York, Karen in Indiana, and Jacqueline in Philadelphia. So welcome to all of you. It's good to hear from you. So John, in Louisville there at the Legal Aid Society, you have a low-income taxpayer clinic. I understand there's a whole network of these. Could you tell us about that and what these clinics are across the country?
So my office receives a grant from the IRS. It's actually run through the Taxpayer Advocate Service, and that is to represent low-income people who have controversies with the IRS, meaning they have a problem of some sort. And it is a matching grant, meaning that half of the money has to come from an outside source, and that can be matched with Legal Services Corporation dollars. There are low-income taxpayer clinics in 49 states and the District of Columbia. Low-income taxpayer clinics fit nicely within Legal Services offices because our clients tend to have these overlapping issues, but they can also be run out of law schools where you have law students receiving academic credit for representing people. They can also be housed in a not-for-profit organization, such as the Accounting Aid Society in Detroit, Michigan, as an example.
Thanks, John. I also want to say hi to Nathan in Atlanta for joining us today. So John, let's jump into some of the common questions that you see in the clinic. Many of these, as you said in your introduction there, pertain to family law. And one of the ones that you mentioned, I believe, in your opening remarks was, can I claim my kids on my tax return? Which seems like a pretty straightforward question, but I gather from your article that it's not always. So can you tell us a little bit more about that?
Yeah, well, the reason it's not so simple is because there are multiple things that you can claim for a single child. There's the dependent exemption, and that it just reduces the amount of income that is taxed versus the child tax credit, which is money that is a credit is taken against your tax versus just lowering your income, and then you take a percentage of your income that you determine your tax on. So probably the best example of this is the claim the dependent exemption. You may be able to claim that even if you don't live with your child the whole year, because you may have if you're divorced, you may have a multiple separation agreement, and you've allocated the dependent exemption to the other parent of your child, versus the earned income tax credit, which has a strict requirement that your child has to live with you for more than half of the year. So you may be able to claim the dependent exemption, but you're not able to claim the earned income tax credit.
Got it. I want to say hello to just a few more people who've joined us. We have Heather in San Diego, Liz in Providence, and Kathy just down the road from me in Nashville, Tennessee. Hello, Kathy, and all of you. And I'll remind all of you who are watching, do send us your questions. If you have tax questions that have come up with your clients, or you're just wondering more about these clinics, let us know. So John, sticking with the family law and tax intersection, I know one issue that you mentioned in the article that I had heard about before was this idea of innocent spouse relief. But I think in my head, I kind of associate that with like married to the mob kind of stuff, not exactly a legal aid type of issue. So how does that come up with our client population?
So let me back up. First, when you file a joint tax return, all right, if you're entitled to a refund, then that is both spouses' refund. All right. If you're entitled to $1,000, it is $1,000 for each spouse. On the other hand, if you owe a debt, then that is both spouses' debt. All right. If you owe $1,000, the IRS can go after either spouse for the $1,000. It's like co-signing on a loan. All right. In when you look at innocent spouse relief, that is the IRS. What they're really doing is, in my view, is they're codifying this. I don't know, this common law theory of, when you both sign the tax return, maybe one of the spouses pulled the wool over the other one's eyes. And so the quote unquote innocent spouse signed that return, not without full knowledge. And so they give, or maybe the other spouse had been the victim of domestic violence. All right. So they're signing that return under duress. So it is not a voluntary signing of the return. And so you can petition the IRS for innocent spouse relief. And if granted, then you can be partially or fully relieved of the liability. The IRS has set up a specialized unit to look at these cases. The unit is actually in Covington, Kentucky, and to do so, you file a form 8857.
All right, thanks, John. A few more people are still saying hello, and I love it because we're all across the country. Kenneth in Camden, New Jersey, Michael in Austin, and we also have folks watching at Lone Star Legal Aid in Houston. So hello and welcome to all of you. John, you mentioned domestic violence is coming into play. Are there exceptions or any sort of allowances in the tax code for situations of domestic violence?
Well, I mentioned that's, if you're making an innocent spouse application, I think that the IRS has really come around to looking at domestic violence as a more significant factor in granting relief. I know that there has been significant litigation in the area of innocent spouse relief, and especially there in Tennessee, Bob Nadler has done a really good job on this. And in fact, Bob has written the manual, a guide to innocent spouse relief, which I'd recommend to everyone if they're looking to make an innocent spouse petition, if they're going to help a client do that. I look at mine every time I fill it out. But Bob and other LITC practitioners have really challenged the IRS on innocent spouse relief and how that's handled by the IRS. And they made a significant change to the law in that it used to be that if the innocent spouse knew that the bad spouse was doing something wrong on their tax return, all right, they would really look at that as a more significant factor. And now they've made domestic violence kind of, I don't know, more important in that analysis. And so that's something that's, I think, helped a lot of legal aid clients.
Thanks, John. And you mentioned Bob Nadler's resource, the book that he wrote, and I'll note to everyone that the citation to that is in John's article that you can find here, povertylaw.org/clearinghouse. And he's an attorney with the Legal Aid Society of Middle Tennessee and the Cumberland. So one of us, right? So I'll also say hello to the people who are watching at Manhattan Legal Services, as well as Anne in Colorado. And I have a couple of questions that have come in, John. One is from Kathy. Kathy says, my clients sometimes receive money as part of a conciliation agreement in a discrimination case. The money's for damages, actual and compensatory. Would this likely affect their taxes? And Kathy, I'll note, I know this, John didn't really get into this in his article, though. He probably has an answer for us. But we do have a forthcoming article in the Clearinghouse, I think it's for January, from some attorneys in Vermont who are going to be writing about specifically kind of settlements and that sort of thing and the tax implications for those. But I'll go ahead and see if John has anything to answer for your question right now.
Generally speaking, if money is I don't know specifically. I'll say that. I don't know specifically the answer to that, but I'll just say generally speaking, if the money is replacing wages, then it is taxable. If it is not, then it's not taxable. Now, this is tax law. There are exceptions to everything because I think tax law is heavily litigated. I know that this is something that I didn't put in the article, but I chose not to put it in there because I think it's probably more appropriate for a personal injury practice. So occasionally, I think legal aid attorneys have these cases where you have a confidentiality clause, and interestingly, confidentiality is taxable if you assign a money value to that confidentiality, then whatever money value you assign that's going to be taxable. Or really the way that this comes up, probably more often than not, or at least it came up in this particular case, if you don't assign a value to anything at all, then the IRS is going to make their own determination on, what is taxable and not taxable, because money attributed to physical pain and suffering, that is not taxable. All right. But if you have money, if you have a settlement where somebody gets hurt, personal injury, and they have, they have some part that said you're not going to talk about this ever again. That's one of the clauses. Then the IRS is going to go in and say, well, we're going to say that this much is taxable and this much is not taxable. There's a very, there's a case that's often cited too. It's Amos versus the commissioner, but in tax law circles, it's referred to as the Dennis Rodman case. And I won't go into it any more than that. You all can look it up. It's a fun read. As a lawyer, I say that it's a fun read. But that just came up. I don't know. I don't know if it came up with that law, but at least it solidified it to say if you don't say anything, that the IRS is going to determine what's taxable and what's not.
Gotcha. I'd say if there's any sort of tease for to make a case sound inviting to read, it would be saying it's the Dennis Rodman case that has a certain frightening appeal. All right, so I want to say hello to David in Marin County, California, and across the country to Michael in Baltimore, and back to the middle of the country to Jim in Indianapolis. Thanks to all of you for joining us. John, we have another question that came in from Kimberly. Kimberly asks, are there any special areas of the tax code applicable to veterans and members of the military? So is there anything that attorneys should be sort of on the lookout for when talking with their clients, thinking about if they're working with veterans or service members, tax issues that might be specific to them?
The issue that has come up with clients that have come through our office is whether their combat pay is taxable or not. And our office is close to Fort Knox, and so I can think of one client where we had the issue where he was a military contractor, and he was under the impression that his income wasn't taxable at all because he was in a war zone. But if I remember correctly, it was. and he had a significant tax bill. So, and that I think that's, that illustrates the problem. I think in communities, you have bad information that goes around, and then the lawyers after the fact have to deal with the consequences of that.
Yeah, I'd say that's probably not limited to the tax arena. I wanted to note that, okay, so William responded, I think, to our conversation from earlier. It says for settlement agreements, will depend on the settlement. General rule, compensatory damages for physical injury not taxable. Most other settlements are, which I think is basically what you were getting at, John. And Kathy, who asked the question earlier, said she should have clarified it would be for housing discrimination. So I don't know if that adds anything to your answer or not, but I will add that to you. Let me move on now, if we could, away from talking about the family law tax intersection and move into talking about taxes and debt. You note in your article that canceled debt is usually considered to be taxable income. So how does this affect some of our clients?
So I'd say usually when a client comes into our office, they're coming at one of the worst moments of their life. And some of that can be attributed to them having significant debt or them having had a home foreclosed upon, and then dealing with the consequences of that. So, like you said, canceled debt is considered to be taxable income, generally speaking, right? If I loan you $6,000 and then 3 years later you don't pay me and I decide, look, you're never going to pay me, and I cancel the debt, I'm required by law to issue a Form 1099-C for that amount of canceled debt. And so what I found is, and I don't think this is just legal aid clients, I think this is a lot of folks. They don't understand when 3 years later, when they get that tax form saying that they owe $6,000, or they have income of $6,000, they're thinking, well, I didn't get any money in this year. The issue is that, or the reason is that it is income in the year that it is canceled. So a lot of our clients will ignore it, or maybe the 1099 form is sent to an old address because that's all that the creditor had. So they get a letter from the IRS later saying, hey, why didn't you report this income? We got something from such and such bank saying that you had this much income. You need to tell us the reason why this wasn't on your return. There are exceptions to including this as income. You can exclude it. All right. One of those is on a debt associated with a foreclosed home or a mortgage deficiency. The law as of right now is that if it's on your primary residence, then you can exclude it from your gross income. All right. The law, and that's the law right now, that is that law was put into effect in 2008 as part of the foreclosure crisis. It has been extended by Congress, but as of right now, it is slated to expire at the end of this year. But also, if you are insolvent, meaning that your debts outweigh your assets, immediately before the debt is canceled, then also that the canceled debt income can be excluded from gross income. To do either, to exclude the income under either exception, and there are others as well, but those are probably those are the only ones that I've dealt with in my years of practice. To do this, you file a Form 982 along with the return and just telling the government, look, this is why I'm excluding this from my income.
Thanks, John. Another topic that you discussed that comes up a lot for legal aid clients is Social Security benefits can have some sort of tax implication. Can you tell us about a common situation where that happens?
So I've seen this come up in two ways. When our clients have some sort of private disability benefit, if they probably have it written into their contract for the private disability that if they receive Social Security, if they're awarded back pay and they receive a lump sum, then they may have to use that lump sum to pay back the private disability insurance. And so the private disability insurance is treated like wages, all right, when it's paid. That's what I found generally. And so you've probably paid taxes already on that. And so when you pay it back, there's a particular way, and I can't remember it off the top of my head. I always have to go to the forms when I do this. But when you pay it back, then you can get there's a way you can get a tax credit for the amount that you paid back to the private disability insurer. The other way that I've seen it come up is when a client receives a lump sum payment of Social Security benefits, is that all of a sudden that they don't understand that they may have to pay taxes on that. And that may be because of the size of the benefit. That may be because of the size of the benefit, and they had some other income. When I see clients when they're waiting for a Social Security determination, they may withdraw money from their 401k plan. So if you have too much income, when you're receiving Social Security, you may have to pay taxes on that. So there is a way that you can, when you receive the lump sum of Social Security, on the form it'll show this much is for 2014, this much is for 2015, this much is for 2016. You can basically backdate what was received and only count the current the current tax year amount received for Social Security, thereby lowering your tax bill.
So our time is running short. So if anyone has a question, please go ahead and send that to us now, and hopefully we can work that in. But John, I want to ask you a question that's not specifically about your article or about tax law, but more about you. I'm curious if you were a tax lawyer first and then came to legal aid practice, or if you were a legal aid attorney first and then sort of evolved into the tax specialty.
The latter. I've done a little bit of everything. I started out doing as kind of a general legal aid practice, doing housing, doing family, doing public benefits, and then just over time, the person who was running the tax clinic left, and they needed somebody to fill the job, and so I stepped into the role. I like it. It is. I think it's a satisfying practice because more often than not, there's a definite answer. And sometimes in legal aid practice, there's not. Or maybe you can just tamp things down for a bit. But that what you've done is a temporary fix. But I'd say more often than not in tax law, you can find the answer, you can close the case, and you can move on to the next one.
Well, speaking of cases, so we had one more question come in. That's a pretty specific question. So if it's going to be a longer answer, I might be able to connect you to afterward. But the question is, can a parent reclaim her children as dependents on her tax return if the other parent already made such a claim, despite the fact that the children do not reside with him?
Yes. I mean, unless you've agreed in using the particular tax form to allocate the dependent exemption to the other parent and said, look, I'm giving this up for this tax year. There's a particular form for that. Of course, I can't remember it right now. But it's in the article, all right, that I wrote. But usually what happens if one parent files and they claim the kids, then what I'll tell our client is what you got to do is you got to file your tax return on paper because you won't be able to file it electronically. File it, claim the kids, and the IRS will sort it out. They'll audit both of you.
Okay, thanks. That was a quick answer. We've had one more question come in, so John, if you can spare a minute
Sure.
for this one. And again, if it's a longer one, then I can connect you later. This comes from Carmen. Carmen asks, if someone gets a large lump sum Social Security for several years and then had health insurance through healthcare.gov and had problems canceling it, is there something that they can do? So John, I don't know if you can answer with those limited facts. If you can't, then possibly we can connect you with Carmen afterward, but I'll give you a shot if it's got an easy answer.
It's not an easy answer for me. All right. And I'm really not the best on healthcare on the topic of healthcare. There is an attorney, and I believe that she is in Vermont, and she is very knowledgeable. She is excellent on this. Her name is, I believe it's Christine Spidell, and she is at a legal aid in Vermont. And I hope she'd be able to help you out with this, with your question.
That's great. Thanks, John. So Carmen, hopefully you can look her up and see if she can help with that question. Which also I should go ahead and mention. So John's focus today was really on the questions that our clients bring to us that have to do with tax. As I mentioned, in January, we're going to have another article that's looking more at kind of what we as attorneys need to consider when we're doing things like settling cases for our clients and the tax implications there. And it actually will come from Vermont. So this is a little tax mecca up there, I guess. So anyway, John, thank you so much. Thanks to everyone who watched today. But John, thank you for being with us. It's been great talking with you.
Oh, thank you for having me, Amanda.
Great. And I will thank all of you. And I'll remind you that you can find John's article at Tax Law 101 for the legal aid practitioner. You can find it at povertylaw.org/clearinghouse. Also, if you found today's conversation interesting and John's article interesting, please join our mailing list, and you'll be notified of our future content that will be relevant for your practice. You can do that at connect.povertylaw.org/clearinghouse. And also remind you that the Advocacy Exchange is now available as a podcast. So you can subscribe to the Advocacy Exchange on iTunes or wherever you subscribe to podcasts. And I'd like to invite you to join us next month. Our next Advocacy Exchange, I'll be joined by Greg Bass. Greg is a senior attorney at the National Center for Law and Economic Justice. We're going to talk about his case in New York that worked to make public benefits information accessible to clients with visual impairments, and how that can be used as a model for work in other states. That will take place on Wednesday, November 8th at same time as today, 1 o'clock Eastern and 10 o'clock Pacific. So I hope that you'll all be able to join us next month. And until then, remember that you're not alone out there. Thank you.